Good morning, everybody. Hello. Welcome to my webinar today. My name's Amanda Chadwick. I'm a senior speaker at Peninsula Business Services, and we're here today to talk about how to avoid costly mistakes when disciplining employees. We run this particular webinar once a month because it's actually so popular. And the reason we run it once a month is because we take about 60,000 calls per month on our advice line, and the highest topic that we always get asked about is disciplinary procedures. That's exactly what, and how to discipline staff, how to get it right, what procedure to follow. And we're going to talk about that today. And it is necessary to have a minimum number of rules in the interests of your organisation. And the rules that you put in place set the standards of performance and behaviour, whilst the procedures are designed to help promote fairness and order in the treatment of individuals. What the rules should be doing is emphasise and encourage improvement in the conduct of individuals where they are failing to meet the required standards, and they're not to be seen merely as a means of punishment. What you should say in your disciplinary procedures is that you reserve the right to amend these rules and procedures where appropriate, and that every effort should be made to ensure that any action taken under the procedures is fair, with your employee being given the opportunity to state their case and appeal against any decision that you consider to be unjust, or they consider to be unjust. And that's really what you should have as an introduction into your disciplinary procedures. And then what you should be mentioning really, just to say and mention that the following rules and procedures should ensure that the correct procedure is used when requiring you to an employee to attend a disciplinary hearing, that they're fully aware of the standards of performance, action and behaviour required, so there's no surprises for your staff, and also that when you do take disciplinary action with employees, you need to put into your introduction that where necessary it will be taken speedily and in a fair, uniform and consistent manner. So one person won't be disciplined in a different way to another person. And that you must reassure them as well in the introduction, in your policies, that they will only be disciplined after you've carried out a very careful investigation of the facts and the opportunity for them to present their case is heard. On some occasions, though, you need to mention to them that temporary suspension on full pay may be necessary in order that an uninterrupted investigation can take place. This is not regarded as disciplinary action or a penalty of any kind. It can be a protection of a member of staff and also to make it a fair investigation. And you might find that in some industries that listen to me, like the care sector, working with children or working with governing bodies, when there is a disciplinary going on, they require you, as per their standards, to suspend people on full pay. That's why the other hot topic that we have on our advice line is always reducing suspension costs. And then what we've got also in the introduction is, other than really for off-the-record informal reprimand, you have the right to be accompanied by a fellow employee at all stages of the formal disciplinary process. And it will also mention that they won't normally be dismissed for a first breach of discipline, except in the case of gross misconduct. And what you've got to remember when I'm talking about disciplinary procedures and rules, etc., is that they're different for each business. So any industry that I'm talking to, they have to remember that their disciplinary rules are different. So don't copy somebody else's contract. And then if you do discipline a member of staff, you must explain the penalty imposed, and they have the right to appeal against the finding and the penalty. So that was what you would include in your introduction. And also in your disciplinary rules, it might be a good idea to mention it's not practicable to specify all the disciplinary rules or offences that may result in disciplinary action, because you're not a mind reader and you can't forward think, as they may vary depending on the nature of the work, in addition to the specific examples that you would give in your employee handbook of unsatisfactory conduct, misconduct and gross misconduct, a breach of other specific conditions, procedures, rules, etc. They should be contained in the handbook, or they should be familiar and be made known to the employee. and this will also result in this procedure being used to deal with such matters. So that's really what you would have in your introduction. But what I would also say is there are some steps that you need to follow, and the basics that you need in place, so you get things right in the first place. So I'm looking for a written statement of main terms. So that's the first thing. These are the basics in employment law. And I know I repeat myself because we hold this webinar once a month because it's so subscribed to. So written statement of main terms, if you don't know what that is, you should by now if you've been listening to my webinars. A written statement of main terms, if you're fresh to these webinars, it's really when I go for an interview with you and I sit in front of you, I ask you where is it I'm working, how much am I getting paid, what are the hours like, and that's my statement of main terms. Those are the written rules. This is, you know, my written contractual terms with you, and this is where I get offended if you try and change it. There isn't anything we can't change. However, you need help if you're changing somebody's written statement of main terms. Job description describes the job and what I'm doing and who I report to. And that's a really good idea to write this when you're advertising a job. The standards and expectations, or the conditions of employment, which would include the disciplinary rules and procedures, go in the handbook. In the disciplinary rules and procedures, this is required by law, and there's penalties for not having these in place. You also have written grievance rules and procedures and appeal procedures as well. I would recommend that to help you with your disciplinary process, because there's areas with sickness that you would like to go through and may result in disciplinary. I would recommend, alongside disciplinary rules and procedures, grievance rules and procedures and appeal rules and procedures, that you have capability policies and procedures. You would use this for ill health, sickness, lack of dexterity, training, performance issues, and it's self-explanatory and it's absolutely brilliant. If you are the manager or the person that deals with staff and people managers, it helps you. Use KPIs and appraisal systems, because if there is something bubbling and somebody's unhappy in the job, you'll find out in your one-to-ones, in your performance management conversations, in your appraisals. And also use KPIs, which are key performance indicators, so that if you are performance-related issues, you've got a benchmark to work with people. Create a paper trail with anything that you're doing. Create a paper trail by using formal documentation and forms. The paper trail will help you, and it's what we would use as evidence, and it's what was required of you. So if you attend a tribunal because somebody thinks they've been treated unfairly, you won't have any defence if you don't have a paper trail. So don't just do things word of mouth. Training and education of management and employees is crucial. Things change, people change over time, and keep up to date with employment law changes. They're just the basics. So things to remember when you are having a disciplinary procedure. You know, we don't want disciplinaries, but we do have them. And if you're having too many of them, you've got to ask yourself why. Something's going wrong in the workplace. But emotions can run high. You're talking about people's future. We're human. So remember, don't use your emotion. Don't lose it in a meeting. Watch what you say, because it will be used and evidenced against you if you have a tribunal. So don't think you've bonded with somebody. And remember, in our experience, the person that will take you to a tribunal you have a problem with is usually the one that used to be your best friend, the one you do the most favours for, the one you've altered their hours or you've had sickness issues. So this is where emotion can take over. So emotionally, don't lose it. Okay? Tribunals are lost because of emotion. If you think they've buddied up with you and they're going, oh, I know, understand, I haven't been very good at the job, don't agree and say, yes, well, you're not, and this isn't the place for you now, is it? Remain in control. This will be used as evidence against you later on. They will remember your conversations and what you've said. Remain calm, no matter how angry you are, and you might become angry. Don't overtalk people and listen to what they've got to say. You know, you are talking about their future here. Be decent and listen to what people have got to say. Be consistent as well. Don't discipline somebody for something and not somebody else. You know, I know that you feel like somebody's been there for 10 years, and they may, you know, a new starter might be treated a bit differently to somebody that's been there for years, but you have to be consistent. Also, Are they guilty? Are they innocent? Remain neutral. Even though they might look guilty, they might not be guilty, because after the investigation, if it's a thorough investigation, you may find out that actually the evidence put in front of you says that they are actually innocent. Investigate thoroughly, even if that means looking at CCTV footage, cameras, tracking, proof, emails. Take the time out, especially if one of your staff saying, please read the emails. Take the time out to get your IT department, whoever, to do a forensics, data forensics, and print some stuff off, even if it's been deleted. And remember, your staff aren't mind readers. I don't like people being left with surprises. I like them to know quite clearly, this is why you're going to get in trouble, so don't do it. The example I give you there is the company mobile phone. I'm giving you a company mobile phone. Use it only for company purposes. Don't take pictures of yourself or send explicit emails or texts to anybody on my company phone, because they'll end up in the hands of somebody who's my client. So make sure your staff aren't mind readers, and let them know what the written rules are for and where they will get in trouble. So there's no surprises later on and they can't say they didn't know. So this is the process with the investigation. It's step one. It's investigate the facts. And the key here is without any delay. Even if the employee seems guilty, you have to investigate, because this is why the statutory dispute resolution procedure came in the first place, which is now the ACAS Code of Practice. It came into play because, and this was 2004, this is because of the amount of tribunals that were coming through that could have been sorted out in the workplace, and if people had investigated thoroughly. Lots of tribunals were happening and lots of employers were losing because they weren't doing it properly, and it seemed that the employee actually was an innocent person. So what the tribunal said is they said, we want you now to do investigations. It's a legal requirement. You have to investigate the facts without delay, and make sure, even if the employee is asking you about things, that you have a look properly and investigate thoroughly. Make sure it's thorough to ensure that you get the true facts in place and that the substance of the allegations are clear. Remember, at this point, though, there's no statutory right to be accompanied at this stage, but consider whether to allow employees at this stage if they request it. Also consider the age of the person. So if you've got somebody who's 16, 17, a young person, and they're having an investigation, for the first time ever, to anybody, it's intimidating because you are worried. So allow somebody of a young age maybe to bring a parent in. So no formal disciplinary action should be considered at the investigation stage, and try and make sure that the investigation manager is different, and if you can, more junior than the manager who will be hearing the subsequent disciplinary hearings. Step 2, remember the ACAS Code of Practice here. It's crucial to this because they will refer to it in tribunal if you get it wrong. It encourages an informal resolution. Consider whether you are proceeding in a formal or informal manner. Still keep notes, though, if dealing in an informal manner, because they are used as evidence. Make employees aware that if further instances, misconduct or poor performance occur, you may take the formal route. Step 3. Consider suspension again. We are still on the investigation stage here. Consider suspension at this stage, and any suspension should be kept as brief as possible, both for the employee and the employer, for suspension costs. Review the suspension regularly. Don't forget about somebody. And we've dealt with companies where the HR person has gone off sick and people have forgot about somebody that's suspended on full pay. Remember the terms and reasons for the suspension should be communicated verbally to the employee at the time of the suspension, and then confirmed in writing as soon as possible. Normally, unless the contract states otherwise, during any suspension, an employee should continue to receive the full pay and their benefits, because taking things off them can make it seem like that you think that they're guilty. Inform the employee who their point of contact is during the suspension period. It's absolutely crucial, this, because if you sat at home and the suspension is going on into days, then weeks, there should be a contact person to keep reassuring the employee at home that this isn't a disciplinary, this is an investigation. Just because an employee is suspended doesn't mean to say that disciplinary action will be taken or that any matter has been predetermined. Reassure the employee of this and make sure they're aware of this. Excuse me. Step 4, inform the employee in writing of allegations and invite to the disciplinary meeting. Make sure that you have written, excuse me to cough a second, make sure that, make sure that you have written and set out with sufficient information the allegations and possible level of disciplinary sanction. This will enable the employee to prepare their side. Include any documentation and evidence that will be used or relied on in the meeting. Inform the employee they have the right to be accompanied by either a fellow employee or a trade union representative, and back this up in your employment law handbook. If you haven't got any mention of that, make sure you change that to fellow employee or trade union representative. Meeting should be convened at a reasonable time and place, and meetings should be within normal working hours. Provide reasonable notice that you are giving the employee the time to prepare. If the matter is sensitive or of a confidential nature, it may be advisable to hold the meeting elsewhere. And if the employee asks for a postponement, consider this request. So step 5 is holding the disciplinary hearing. Set the scene. Check that the employee is comfortable. We are talking about somebody's life and future here. You know, some people have never had a disciplinary before, and, you know, they're not used to this and they find it upsetting. They're nervous. You are talking about affecting them, because ultimately, if somebody loses the job, it will affect their family life and their home life. So, you know, reassure the person at this stage and set the scene. Check that the employee is comfortable with the arrangements made and that they have received all the documentation. Explain the charges against the employee and explain and go through the evidence that you have. Give the employee a chance to ask questions and then present the evidence and present their evidence. Call relevant witnesses. Prior to closing the hearing, check with the employee whether they have anything further they would like to add or say in their defence. You then have to summarise the meeting and then adjourn to consider any follow-up or decision. You know, if at possible at this point, ask the employee to read and sign the notes of the meeting, to agree to accuracy and to provide comments. Now, tips for the disciplinary hearing. Excuse me. Approach the hearing bearing in mind that you want to avoid an employment tribunal and hearing resulting from this process. Remember, you are the chair. Let the employee present their response to the alleged matters of concern. Have a note taker present in the disciplinary hearing, and both parties should ultimately agree the notes of the disciplinary hearing. The focus of the disciplinary hearing should be on the matter of concern and not on other stuff. And at this point, be aware of tactics. Employee may try to and attempt to divert and deflect the hearing away from the reason. Remember, you are in control. So, don't appear during the disciplinary hearing to make the decision there and then. The decision or outcome don't appear to make or advise in the disciplinary hearing, as this would appear as no consideration or reflection has taken place with regard to what the employee has stated in the disciplinary hearing. Advise of the outcome and the decision in person and in writing. Issue the appropriate level of warning or dismissal, and it should be in line with your disciplinary procedures. Provide the right of appeal against any level of warning and dismissal. Normally and ideally, a different individual should hold each stage of a disciplinary situation, i.e. the investigation, disciplinary hearing, and the appeal. So step 6 is the process of appeal. Now, you inform the employee in writing of the decision, and at this point it is absolutely crucial, and you have to do it in line with the ACAS Code of Practice, and that is actually to write in the decision letter the offer of an appeal. You have the right to appeal against our decision. Any decision that you make should only be made after the disciplinary hearing has ended. You can inform the employee verbally of a decision after a short adjournment, but you have to inform the employee in writing of any decision as soon as possible after the hearing. The decision letter must set out sufficient details of any reasons for any decision to impose formal disciplinary sanctions. The decision letter must contain the right of appeal. The deadline date for appeal to be submitted and recommended by ACAS is 5 working days. And I think at this point I'll just pause and stop for a second to tell you about a story and to tell you about a disciplinary I was involved in many years ago for my brother-in-law, okay? And it was years and years ago, excuse me, I don't know, I've got a frog in my throat today. And I think, you know, that might be because of too many coal fires, maybe. So basically, this is what happened. I'll show you where they went wrong. I then went on to represent in tribunal, and it was I think it was actually the first case to be won under the statutory dispute resolution procedure. So here we go. This is the example. It's quite a few years ago now, and my brother-in-law was working for a company, and he was having a bit of a hard time. He's a really hard-working person. Comes from Thailand, been married to my sister for a long time, and they were in the process of adopting a child. Now, what happened was he was working in this workplace, and because he was such a hard worker, it was a food outlet, he sort of had the mickey taken out of him from the younger staff because they'd leave lots of work for him to do. He's a supervisor, but they certainly didn't treat him like one. And he worked very, very hard. Now, in his own country, he was a qualified architect, but over here, that wasn't actually recognised. So he's working away, and he did, just before he'd gone off on his days off absence from work, you know, his leave, he'd let them know and notified them that one of the boiler at work, the boiler that cooked some of the fast food, had been faulty, and it kept breaking down. It was holding staff up, and he'd reported this fault before he went off on his day's leave. When he returned to work, which was about 4 o'clock in the morning on the day he returned to work, he found that the boiler was still broken and nobody had followed up on the fault. So he actually mechanically tried to fix it, and he successfully fixed it. What he did is he then took some voice messages and phone calls, and several members of staff rang in sick. He also noticed, because people knew he was going to be on work the next day, that they hadn't cleaned up from the shift before. And in fact, they just left it a mess because they knew that he would clean it up without complaining. So not only did he find himself fixing a fast food outlet, cleaning up after people that should have done their job the night before, but he also found himself with less staff members than he should have had. So at the time ticked by, and he was due to open up at 5 o'clock in the morning. And what happened next was his supervisor, his manager, walked in and said, "What the hell are you going on? You haven't got the burgers cooked yet. You haven't got everything opened up. Come on, you've got to do it now." And spoke to him in a really disrespectful manner. Whilst talking to him, she lifted her skirt up right up to near her bottom and pulled her tights up in front of him, which was, you know, offensive to anybody. And then at that point, what she did is she pulled a finger out at him and she started poking him in the face and said, "Come on, get it, you get your act together, get everything up and running. What the hell are you doing? You should be doing this." And he was quite upset by it, but he carried on doing his job. Repeatedly, in the next 15 minutes, she kept coming back in and pressurising him, and he was getting more and more stressed. And at this stage, he still hadn't got the burgers cooked, and she insisted that he opened the unit. Now, the problem was he couldn't open the unit without the burgers being cooked. And by law, you have to actually fill in a temperature sheet. And he was refusing to fill a temperature sheet in because the burgers weren't right yet. And the temperature, the fat wasn't at the right temperature, so they would be undercooked. But she was insisting that he opened the unit. And he said, "No, because once you get busy, we might serve burgers that aren't right temperature." And she was very aggressive. At this stage, she said, "If you don't open up, then, you know, you can go home. You're sacked." And at this point, what she did do is she pulled him by the arm, got his coat because he wouldn't opened up, and pulled him to the door. The problem for her was it was all captured on CCTV. Now, also what happened at this stage is that my brother-in-law was absolutely distressed. He rang my sister, he repeatedly rang her, he was really upset. He rode home on his bike, he got home, and he was really, really upset because he knew that the lady had said, "You've lost your job," and he knew that he needed to keep the job because he was going through the process of adoption. Now, what happens next is that he rings up the head of HR, who doesn't take his call, and when she does take his call, she reassures him and says, "Look, I'll look into this, don't worry." He's left with no notification of anybody. Nobody phones him. He's got no communication. And then what happens is he then is called in for a meeting. And what happens is he says, "Can my sister-in-law come with me?" which is me. Big mistake. And then what happens is they say, "No problem." So I walk into the meeting with my laptop with my brother-in-law to go to what she says is just an informal chat. My brother-in-law has written a letter to say how losing the job will impact on his family, his family life, and what had happened that particular day. how aggressive the member of staff was, but also as well the way that she had treated him. He also mentioned the fact that they were going through an adoption. It was really important that he didn't lose his job. He wouldn't, and by this stage the manager was saying, he said, shove your job, and she was saying he said that. He was saying, I didn't say that. I said I wouldn't open up because the burgers wouldn't be cooked. Now what happens is we're going into an informal meeting, and I say, can I take some notes for my brother-in-law? The lady says, no, you can't. This is just an informal chat. It needn't be written down. It's an informal chat. First mistake. The second one is that she then starts talking to him and reassures him, and he begs and begs and says, please, 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 will you look at the CCTV footage? You will see what I'm saying. Please check the log sheet for 2 days prior to my leave when I reported the fault, on 2 days prior to my return, where I reported the fault that was happening with the broiler. He also pleads with her to check with the manager that maybe she might have been under pressure to open up, and that she may have said the wrong thing, and that we could sort this out really right at the very beginning. Also, he begs her that this really is going to affect his career with the company, and if he loses his job, what's going to happen is that, it's going to affect the adoption, because, he's a hard-working person, needs to be in work. So now what happens is he sits in front of her and he says, I prepared a letter. As he starts to read the letter, he gets really upset, so I read it for him. And then the lady says, it's okay, I really will look into this. I'll check all the CCTV footage. I'll check the people ringing in sick. I'll have a look at the state of the unit. I'll look at everything that you're saying, and I'll consider it. I'll get back to you shortly. Now, I drive off home. I drop my brother-in-law off, and by the time we've got home, he's sat there waiting, and he's waiting for his wife to return from work. Literally within 2 hours, a hand-deliver letter arrives at his house, and it's written, it's typed up, it's already prepared, and it says that he's been dismissed. Where are the steps that I've spoken about earlier to you? Where are the true investigation, looking at CCTV and listening to witnesses and looking at everything and doing a thorough investigation? This went to tribunal, and he won. Now, what I have to say to you is that you've got to learn from this. Even if you don't know the full facts of an investigation and somebody's coming to you and they're pleading with you to look at the full facts, you have to look at the full facts, because it might not always be as it seems. And I also deal with mediation as well. And I truly believe that most of the tribunals that we have, most of the issues that we have, can be sorted out if people get the right policies and procedures in place, but not only get them in place and tick the box to say, yes, I've done that, but they also follow those procedures that are set. The disciplinary steps and the ACAS code of practice make perfect sense to me, because they give you the opportunity. They say this is what you should be doing, because it helps you get the right facts in place, and then it can give you true facts without assuming that somebody's guilty. So learn from this story I've just told you, and learn from it. They did actually, by the way, happy ending, they did get adopt their child. So any decision should only be made after the disciplinary has ended. Inform the employee verbally of your decision, and you have to inform the employee in writing of any decision as soon as possible. The decision letter must set out sufficient details of any reasons for any decision to impose formal disciplinary actions. The decision letter must contain the right of appeal. The deadline date for appeal to be submitted and recommended by ACAS is 5 working days. So if the employee appeals, send written invitation to attend the appeal hearing. Employees have the right to appeal. Remember this. Don't be offended if somebody says, I want to appeal. Employees should let you know the grounds for their appeal in writing. You can ask them to set out full details of the ground prior to the appeal hearing. If possible, the appeal hearing should be dealt with by a manager who has not previously been involved in the process. If possible, try and use a more senior person than the person who made the original decision. Send employee a written invite to attend the appeal hearing. The written invite should set out the proposed arrangements for appeal hearing, contain the identity of the appeal manager, and should also inform the employee they have the right to be accompanied. Appeal meetings should be held at a reasonable time, place, and during work hours, and consider any requests for postponement. So when you do hold the appeal hearing, the appeal manager should have had access to the evidence compiled during all procedures, the investigation and initial disciplinary stages. The appeal manager should not confirm with the initial decision maker prior to the appeal. It is possible that any procedural defects in an initial disciplinary hearing may be corrected on appeal, if the appeal hearing is sufficiently comprehensive. Set the scene again by asking, is the employee comfortable? Have they had all the documents and happy with the arrangements made? Listen and give employee a reasonable opportunity to present their grounds for appeal. Call relevant witnesses. Prior to closing the meeting, check if the employee has anything further to add and sum up the meeting. Adjourn to consider any follow-up action or decision, and if possible ask the employee to read and sign the notes of the appeal hearing as accurate, and also if they want to provide any comments. So step 9, informing employee of the final decision. You do this in writing. The decision is made after the appeal hearing. You can inform the employee in the first instance verbally, but only after a short adjournment. Employees should be informed in writing of the result of the appeal hearing decision as soon as possible after the appeal process has ended. In cases where the dismissal has been overturned, consider the level of support in facilitating return to work. So, because, somebody's returning to work after maybe sometimes a long time off. So it's a great idea to consider the level of support you're supposed to give and, how comfortable they're going to feel within the workplace. If the employee is not successful in their appeal, the letter must contain the decision and set out the reasons why the appeal was not upheld. So, I want you to listen to what I'm saying today. These rules are not put in place. They're there to, just to put in place because somebody decides that, oh, we'll put these in place. They're put in place because the tribunals knew that loads of the tribunals shouldn't have gone ahead. They could have been sorted out in the workplace. They're there. This is here as preventative measures. I truly believe the incident that I spoke about earlier on involving my brother-in-law many years ago could have been solved right at the very beginning when he said speak to the other manager. Imagine if she'd have said, yes, I was under pressure that day. I didn't mean to, to get angry and to sack him. But I was just angry with myself because I had lots on my plate. Imagine what that would have been stopped right at the very beginning. Would have had any pressure, any stress, and it could have been sorted out. So a lot of these problems can be sorted out, but let's face facts, we do have problem employees. And it's horrible if you've got a problem employee and you know that they've done something wrong and you do dismiss them, but you do it incorrectly and you lose at tribunal. That's such an awful feeling. So let's get these steps in place. They go in your conditions of employment. You mention it in your statement of main terms, the disciplinary procedures. Legally, you have to have them in place, but get them right and follow the right procedure. This is why it's one of the most talked about conversations on our advice line, because even experienced HR professionals and experienced people that deal with employment law issues every day still ring up and say to another professional, am I doing the right thing? And it's a nice pat on the back to know that you are, because we don't want to have mistakes that end up in a tribunal. So top 10 hints and tips for dismissing an employee and not ending up in a tribunal. Have a blooming disciplinary procedure in place, for goodness sake. Make sure your employees are aware of the procedures and what misconduct is. Be careful of assumption. Sack an employee based on assumption. You know what? I think you're going to have a tribunal. Let the facts speak for themselves. And in fact, have you ever tried that, to stop talking and just listen, and then people get uncomfortable and they say more than they should? So it's a really good idea to use that tactic when you're doing an investigation. Aim to be fair, consistent and reasonable in the application of the disciplinary procedure. This will help to avoid tribunals. Follow your processes, not somebody else's. We've all got friends in HR and solicitors and barristers, but just listen and follow your own processes, because you'll end up in trouble by listening to somebody else's. Okay, balanced and neutral language. Remain calm and in control. Don't prejudge and don't preconsider. Consider and reflect, and consider the bigger picture. So I thought at this point, what I would do is I would just go through a couple of the rules that we have in place that you might, just to give you an example of what, say, for example, rules covering, say, unsatisfactory conduct and misconduct, and then gross misconduct, and then, going on to serious misconduct. So I thought I'd mention some of them. So this is what we have in place in our handbook. This is my handbook that I have for Peninsula. Rules covering unsatisfactory conduct and misconduct. And remember, these are examples only, and it's not an exhaustive list, but it will say something like, you will be liable to disciplinary action if you're found to have acted in any of the following ways. So this is the first one: failure to abide by the general health and safety rules and procedures, smoking in designated non-smoking areas, possession of alcohol on the premises, persistent absenteeism or lateness, unsatisfactory standards or output of work, unauthorised use of email and internet, rudeness towards clients, members of the public. I think I might be rude to all of you now, and then I might go through this procedure as well. I can tell you what it's like then. So rudeness towards clients, members of the public, management or fellow employees, including objectionable or insulting behaviour, harassment, bullying or bad language, failure to devote the whole of your time, attention and abilities to our business and its affairs during your normal working hours, failure to carry out all reasonable instructions or follow our rules and procedures, unauthorised use or negligent damage or loss of our property, failure to immediately report damage to property or premises, use of our vehicles without approval, failure to report any incidents whilst driving our vehicles, whether or not personally injured or that vehicle damage occurs. If your work involves driving, failure to report immediately any type of driving conviction or summons which may lead to your conviction, and loss of driving licence where driving on public roads forms an essential part of the duties of the post. And then serious misconduct. This is where one of the unsatisfactory conduct or misconduct rules has been broken, and if upon investigation it's shown to be due to the employee's extreme carelessness or has a serious or substantial effect upon your operation or reputation, it may be issued with a fine or written warning in the first instance. They may receive a fine or written warning as the first course of action if an alleged gross misconduct disciplinary matter upon investigation is shown to have some level of mitigation and is treated as an offence just short of dismissal. Failure to comply with the company's smoking rules also falls into the category of serious misconduct. As such, it's going to be repeated again in gross misconduct. Smoking should only be permitted, and you should mention this in their own time, i.e. before they start work, during their contractual lunch break, and after they finish work. If they are found smoking during the working hours, this will be deemed, I would think, as serious misconduct, and will be issued with a final written warning, and also have the leave entitlement. Oh, this is something explicit to us. But if you are found smoking during your working hours a second time, this will be deemed a breach of the first or final warning and result in dismissal. So let's go through some of the rules that we have in place covering gross misconduct. And these are examples only, again, and not an exhaustive list. You will be liable to summary dismissal if you are found to have acted in any of the following ways. So, grossly indecent or immoral behaviour, deliberate acts of discrimination or serious acts of harassment. So, not sure if at my last Christmas party I was grossly indecent, but I don't think so. But, you know, this is something that what I'm going to be talking about on Friday, by the way. I'm going to be talking about Christmas parties, so you might want to listen into that. So, grossly indecent or immoral behaviour, deliberate acts of discrimination or serious acts of harassment. Dangerous behaviour, fighting or physical assaults, incapacity at work or poor performance caused by intoxicants or drugs, selling, possession or use of illicit drugs during or outside working hours, deliberate falsification of any records including timesheets, absent records and so on in respect of yourself or any fellow employee. Undertaking private work on the premises. You know, as I'm reading this, I'm actually thinking, gosh, I have dealt with so many cases that fall into these categories. So undertaking private work on the premises and or in working hours without express permission, working in competition against us, taking part in activities which result in adverse publicity to ourselves, which cause us to lose faith in your integrity, theft or unauthorised possession of money or property, whether belonging to us, another employee or a third party, destruction, sabotage of our property or any property on the premises, serious breaches of the health and safety rules, including those within the Employee Safety Handbook, which endanger the lives of employees or any other person, or interference with or misuse of any equipment for use at work that may cause harm. And then, you know, that's just an example of some of the disciplinary procedures. And that just gives you an idea of what you should have. So abuse of the personal harassment policy is in there as well, abuse of the protected disclosure provisions, and gross insubordination and or continuing refusal to carry out legitimate instructions. I hope I've helped you today and given you an idea of what you should have in a disciplinary procedures and what process to follow. I hope you've learned from my own true story as well of how companies can go, you know, fall foul of the not following the steps. So, if any of you are listening to me today and you would like to have, you know, see other recordings that I've made on YouTube, webinars, and you want to have these slides later on, these slides and the recording will be on YouTube later on today. And the connection that you need, is www.youtube.com/PBS Press Office. I repeat and read everything out just in case anybody's wondering why I actually talk a lot. Is because we do have people that are blind actually listening to me today. So I read everything out so people can write it down. So that's www.youtube.com/PBS Press Office. The telephone number, if you'd like any advice, this is not for Peninsula clients. For Peninsula clients, you are insured for everything that we write and everything we say to you. So remember, if you want any help with disciplinary procedures, that's what you're paying us for. If you need any help with writing any new policies and procedures, don't sit there struggling. That's what we are there for, to put our arm around you and help you every step of the way. For non-Peninsula clients, if you would like some free advice, you just give us a ring on 0161 836 9576 and quote webinar 0013, my lucky number. And if any of you are sat there thinking, actually, I'd like some editorial writing, I'd like to email Amanda and ask her about pension events or any other events that we're hosting within your area, remember, contact me directly on amanda@peninsula-uk.com. I hope you've enjoyed today's webinar. I hope you've learned something from it, and I hope to speak to you again soon. Thank you very much, and goodbye.